Peace and love. I'm back once again. The Sagent. Eternal Lamont L. And the Sagent is what? A compound word. And the sage is being historically classified as the ones who know. An agent is someone who conducts or transacts business on the behalf of another. I'm transacting and conducting business on behalf of the Most High, the highest order, natural law, divine law, the law of the land, LAW, land, air, water. Peace to all my American nationals, Moorish American nationals, Islam to the Moors, Assalamu alaikum to my Muslim family, and peace to anyone who I left out. So, agent, that's a pretty interesting word, because the subject of discussion today will be about attorneys. That's going to be the subject of discussion today. Attorneys. And why are you so comfortable with walking into court with one of these people or persons, excuse me, because they're actors in a public play? You were learned to, anytime you had legal trouble, go hire an attorney. And people use words interchangeably when in fact they may be synonyms, they may be of the same nature, but they cannot be used interchangeably, because there are two distinct differences between a lawyer, an attorney at law, an attorney in fact, a power of attorney. What do? When you hand over power of attorney, you give what? Authority to someone else to act on your behalf. Okay? So, well, let's dive straight into it. So, a good question for you to ask yourself is, should I hire an attorney? And this is not meant to be legal advice or construed to be legal advice. It's only for informational, educational, entertainment purposes only. Now, a good question that you should ask yourself before you go into a public play is, do I need an attorney? And after you ask yourself the question, do I need an attorney? We need to come up with facts to support our determination if we should proceed with hiring an attorney or not. So to whom, or what is an attorney's first duty? Well, in Corpus Juris Secundum, it's a legal encyclopedia. In volume 7, in section 4, it says attorney and client. It's titled Attorney and Client. And it quotes an attorney under attorney and client in Corpus Juris Secundum, volume 7, section 4. His first duty is to the courts and the public, not to the clients. And wherever the duties to his client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the latter. So here go those terms again: former and latter. Former means the first, latter means the second. So he said his duty is to the former. Who was the former? What's the first entity that they named in this section? What's the court? He owes his obligation and duty to the former, which is the court, which they spoke of the court first, and then the client. The former must yield to the latter. Client. You on the backside of this, my man. You not his first duty and obligation. Man, I gave my attorney $30,000. I'm straight. So you sit in the county, and you sit in the jailhouse doing all this time, and you done gave this man all this money. And he took your money and put carbon ceramic brakes on his S63 AMG. You can't even pay your light bill. But you managed to scrape up what money you did have to give it to somebody who owes their first duty to the court and not you. Does it make sense? Well, to me, it doesn't. The office of attorney is indispensable to the administration of justice and is intimate and peculiar in its relation to and vital to the well-being of the court. An attorney has a duty to aid the court in seeing that actions and proceedings in which he is engaged as counsel are conducted in a dignified and orderly manner, free from passion and personal animosities, and that all causes brought to an issue are tried and decided on their merits only to aid the court. That's funny that they said an attorney is free from passion and personal animosities. Well, it seems to me like an attorney is passionate about getting my money. He's not free from his passion or personal animosities. Hell, this attorney might be representing someone or acting against someone who he has a vendetta against because of what he did. More like a state's attorney. We are dedicated to getting these criminals off the street. It sounds like he's pretty passionate about that. It sounds like he has an animosity against people doing certain things. So, with that being said, it doesn't make sense to me. A dignified and orderly manner. What's dignified about when you go in there and somebody's subjecting you to the pains and penalties of an arrest warrant, or being locked up or held in contempt of court for exercising your rights? Does that sound dignified, orderly? No, not to me it doesn't. Well, if it does to you, then you're correct. I can't tell you if you're right or wrong. It comes down to opinion, but the law is scientific. The law is specific. We can opinion whatever we want to, but the black and white is black and white. So, you might want to ask yourself another question after you realize why you may or why you may not proceed with soliciting an attorney. What is the legal relationship between an attorney and his or her client? Okay, from Corpus Juris Secundum, Volume 7, Section 2 and 3. It says attorney and client. And I quote, and the term is synonymous with attorney. Therefore, anyone advertising himself as a lawyer holds himself out to be an attorney at law, or counselor at law. So, let's see what the word attorney means. According to Black's Law Dictionary, page 163. But you know what? Let's go back. Let's recognize the etymology of the word. And the base word of attorney is attorn. So it seems like a compound word. Attorn. Black's Law Dictionary, page 163. To turn over. To transfer to another. Money or goods. To assign to some particular use or service. A turn. So, does it sound like this attorney is maybe turning you over to the court? Because you implied by walking in this public play with the officer of their court, to which whom exists outside of your society as a national, they know you're incompetent. You hired one of us. You don't know what's going on. I can see the sneaky look on their face now. Yeah. Well, we got us one. Hey, Mr. John Doe, how you doing? Good morning. What's the state's offer? Well, Your Honor, we're prepared to offer John Doe 100,000 days in the county in an indefinite fine. Well, what does the attorney for the defendant have to say? Well, Your Honor, I told my attorney that was a good deal to take, and we're going to plead guilty and take that deal. What? If you hire an attorney, it's almost 100% possibility that you will become the surety for whatever debt is being collected. Yeah, criminal, civil. Okay? That's a fact. If you walk into a criminal case with an attorney, He might play around and act like he's here to advocate on your behalf, and I really care about you, and I really want to see you go home. But would tell you to waive your right to a trial and take a deal. Now, don't be a dumbass and go in there and go to trial if you know you did it. Okay? That's why as nationals, we conduct and carry ourselves a certain way, because we can only be held to the natural law, which is thou shalt not kill, steal, murder, maim, rape. Don't covet your neighbor belongings, possessions, his wife, and no none of that. Do what you want to do. The golden rule, remember? Do unto others if you have others do unto you. So it's common law, which is common sense. You know you're not supposed to be hopping through your neighbor's window. You know you wasn't supposed to take that money out of your dad's penny jar. That's the law I'm being upheld to, not anything statutory. So to atturn means to turn over. That's the first three words of the definition of atturn, to turn over. Now, let's see what an attorney is. Black's Law Dictionary, next page, 164, 4th edition. Attorney, in the most general sense, this term denotes an agent or, check this out, a substitute, or one who is appointed and authorized to act in place or stead of another, or steed. What's a steed? The thing that the horse stand in. That's the horse's place. Okay, so when you hire an attorney, he's an agent or a substitute. That's more like the term. He's substituting you and your proper person to stand in as a fiction. Someone who can be adjudicated by the courts. A fiction. Once again, and I've said this about fictions. In Penhallows versus Doan's administrators. Inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interfere only with other artificial persons, the imaginary, having neither actuality nor substance. Is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate artificial persons and the contracts between them. Now, if you didn't know, legal fictions were created to give courts jurisdiction. Snyder versus Newell. Fictions were created to give the court jurisdiction. So, hey man, you throwing a monkey wrench in our plan by walking in here without an attorney. Well, do you wish to go pro se? No, I'm not going pro se, because pro se is a license to practice law in the court on that day. Are you representing yourself? No, I'm not representing myself. I present myself as a man here, making a special restricted appearance as a third-party intervener on behalf of the defendant to discharge all obligations outstanding. This is your social security number. I don't have a social. I'm a private national. I don't have a social. Why would I have one of those? The socials are assigned to fictions. So, you got your attorney. You spent your 30 good 40, 50 grand for the guy who's getting ready to turn you over to the man he had breakfast with this morning. They bump into each other when they pick up their children from school. They work out at the same gym. His wife goes to visit his wife to drop off cookies and baked goods. They go fishing together. Are you getting what's going on? Are you getting my point? That's a glaring conflict of interest. How you going to represent me? Represent. And you and your man was just kicking it, drinking beer last night on the couch. And he's the adversary. So, acting at his finest. That's why I call it a public play. He fakes and pretends to be concerned about your private interest and your freedom when he is an officer of the court and his duty is to the court before you. So if anyone appears before any court in interest of another and moves the court to action with respect to any matter before it of a legal nature, such person appears as an advocate, as that term is generally understood. The phrase as an advocate in a representative capacity as used in the statute regulating the practice of law, implies a representation distinct from officer or other regular administrative corporate employee representation. So he's representing your fiction. He can't represent you. You guys don't share nationalities. And he's operating in a corporate capacity. How could he represent a living man, a private national? Only licensed attorneys can represent fictions. Well, sir, are you licensed to practice law in this state? Well, the practice of law cannot be licensed. And the practice of law is an occupation of the common right. It's occupation of the common right. If I understand the law and I bring the law and I am the law and I enforce the law and I'm learned in law, I'm a lawyer. Turner Lamael is a lawyer. I'm not an attorney. I'm not going to stand in your stead. I'm standing on my own. I got to defend myself over here and stand on my square. So you have different types of attorneys. Okay. So let's see what the difference between attorney at law, which is the man or woman that you solicit to come help you get out of trouble. An attorney at law. An attorney, and the difference between attorney. In fact, Black's Law Dictionary, 4th edition, page 164. Attorney at law, an advocate, counsel or official agent employed in preparing, managing, and trying cases in the court. An officer in the court of justice who is employed by a party in a cause to manage it for him. So, what does that imply? If you hire an officer of the court to manage a cause for you, you are publicly and openly declaring that you're incompetent to resolve this issue on your own. Now, that's not always a bad thing. If you go into some of these complex cases, or Johnson versus Johnson and all these things of that nature, or anything like that that's complex on the public side, accounting, tax law, and things of that nature, clearly a great majority of us are incompetent in these endless yellow brick roads of statute books. So if you're actually standing to win a lawsuit in a civil instant, well, I would consult a public attorney or a private attorney, because we're contracting. I have the right to say, hey, I'm going to give you this much money if you win this much money for me. And it'd be in my best interest to hire this man because he's well versed in their fictional laws, right? But what about as a national? In some fiction or public entity or a public person brings an action, and they want you to believe that the action is against you. Would you hire an officer of the court to manage that for you? No, because by soliciting an officer of the court to manage an affair for you, traffic, criminal, then you're openly declaring that, hey, I admit to the jurisdiction of the court. I'm incompetent and I'm a ward of the court. And I hired an attorney to manage it for me. So, where do you make your critical mistake? You sit back, you kick your feet up, and you think you got it made. No, you're going to jail. All right? I'm just letting you know right now. You're going for the ride. Oh, I don't want to go. I don't want to go. You're going. So your best bet is to learn a little bit of the law. Even if you don't know a lot, when you learn ones and twos, the basics like definitions of words, and comprehend what type of language they're speaking in the public place, you be in a good position to help yourself. You be in a good position to help yourself. And don't be surprised if an officer of the court, maybe the judge, or an attorney who you just fired because you learned the law, tells you a man who has himself for a client has a fool for a client. So you want me to believe that since I chose to prepare myself and present myself and defend against any action, that I'm a fool because I don't trust your attorney to turn me over to you? I'm a fool for taking my destiny into my own hands? Why would somebody try to scare me out of protecting myself? Somebody walk up on you right now and punch you in your mouth? You gonna tell him, hold on, I'm finna go hire Mike Tyson right quick to come beat your ass? No, he's gonna continue punching on you. So if somebody physically assaulted you right now, would you ignore the first option of defending yourself to go hire someone else to defend you? No. Win, lose, draw. You get out there. If somebody hands you your ass, respectfully, then respect it. Because we know what happened to the sore losers. They end up having to hire an attorney because their pride was so far in the way. Now he's fighting a murder because you deceased a man for losing a physical battle that you agreed to. What's up? You jumped in it, didn't you? All right then. So why do that? Now, an attorney in fact, let's see what the difference between an attorney in fact and an attorney at law. So an attorney in fact, same page, Black's Law Dictionary, 4th edition, page 164. An attorney in fact is a private attorney authorized by another to act in his place and stead, either for some particular purpose as to do a particular act or for the transaction of business in general, not of a legal character. This authority is conferred by an instrument in writing called a letter of attorney, or more commonly, a power of attorney. So, with you being a trustee over your monopoly piece, your trust, you would have trust documents in place, a security agreement. You know, this all comes with being a secure party creditor and standing on the fact that you are national and not a public fiction. Then you will be the attorney in fact. So when I, for educational purposes, walk into a public play, I establish the fact that I'm an aggrieved man. I'm the living man here making a special restricted appearance on behalf of the defendant as a third party intervener. So you have paperwork to prove that you're actually the attorney in fact, because you have it expressed in writing, power of attorney over this fiction. So the attorney at law, which is the guy who comes out here with the cheap cologne on, the penny loafers, the 1970s style slacks, and the not matching blazer, a blue blazer with a red tie. And his breath stinks, smells like cigarette and coffee. He don't even remember your name. He's an attorney at law. You never expressed to him by a power of attorney that he had authority to stand in your stead. But you implied to the court when they say, we're going to give you a public pretender. You implied by your silence that you agreed to accept his services. You agreed to accept the public pretender's services by way of not objecting to them. For the record, when I was approached by a public pretender before a court date for entertainment purposes, I asked that person who she was. Well, my name is such and such from the public pretender's office, this, that, and the other. I've been assigned to represent you. I said, well, no, ma'am. How can you be assigned to represent me if I didn't solicit your services? She said, well, the court said, well, it seems like we have an issue here now, ma'am. Have you notified the court or the IRS by way of IRS Form 56 that you're acting in a fiduciary capacity for the defendant. Oh, well, what do we have here? What is the IRS form? Well, the Form 56 relates to your fiduciary capacity over a matter. Do you have that? Well, no. Well, are you one of those sovereign citizens? No, ma'am. I can't be. Don't let the stripes fool you. Don't let the handcuffs fool you. I'm a prisoner of war. No matter what the charge may have been. So do you still fight in custody? Of course. Yes, you still fight in custody. Yes, you still stand on what's right. So when we go out here into this public play, ma'am, please do not speak or advocate on my behalf. So we walk into the courtroom for entertainment purposes. And the first thing that she does is says, Your Honor, my client, objection. Well, Mr. Turner, what seems to be your objection? Well, for the record, I just let this lady know in the hallway I haven't solicited her services, nor has she notified the court or the IRS that she's acting in a fiduciary capacity. She cannot and will not represent me, and I require her to make her withdrawal from the record right now here in open court. Well, Your Honor, my client, objection, ma'am. Do you not see what I just said to the judge? I just respectfully told you I do not wish for you to speak on behalf. And what they're going to do? Well, you have to be admonished on your right to waive your right to an attorney. Well, you can do whatever you need to do. She just needs to get off this case. Okay. So I have another court date the same day at 1:30 in the afternoon. And they send the chief public pretender in there. And he came in, he was a man of tall stature. He was like 6'4", 5". And he tried to come talk to me with some bass in his voice. I don't know if that was his way of intimidating me, but it just doesn't work. Hey, I'm such and such I'm the chief public pretender, and I've been assigned to your case. Hey, look, man, I'm going to tell you the same thing that I told you the young lady in the hallway earlier. Well, I know what you told her, and this, that, and the other. Hey, sir, you kind of making it hard for me not to disrespect you. When we go in here, same thing. Please don't speak or say anything on my behalf. Once again, Your Honor, my client, objection. Your Honor, my client, objection. Mr. Turner, objection overruled. No. Objection. If I let him talk, I'm implying that I'm okay with what he's saying, and I'm not. I don't want you on this case or around me in any type of way because he's a solicitor. He's a barrister. In England, in her colonies, a barrister is a person entitled to practice as an advocate or counsel in the superior courts. A solicitor is a person whose business it is to be employed in the care and management of suits, depending in courts of chancery. In the great majority of the states of the Union, where law and equity are both administered by the same court, it's naturally come about that the two offices of attorney at law and solicitor in chancery have practically been consolidated, although in federal equity practice the term solicitor is in general use. So what is this attorney soliciting? You, your commercial energy, your time? Is he soliciting you to come in there to make an agreement so everybody in the court, which would be the judge, the clerk, the prosecutor, the attorney, benefits from your ignorance? Is that what he's soliciting? Someone who's dumb, deaf, and blind? Is that what he's soliciting? So we see there's a distinct difference between an attorney in fact and an attorney at law. Attorney at law is an advocate or a counsel, and he's employed by a party in a cause to manage it for him. He's an attorney at law. He's managing your case for you. An attorney in fact, you've expressed this through a written agreement. Okay, a letter of attorney, a power of attorney, and you've turned this over to him, the legal authority, by way of this expression. So are you kind of understanding now why when you go into the courtroom and you try to speak, they say, well, you can't speak on the record. You're dead now. Somebody else standing in your stead. We speak to you by way of your attorney. I was sitting in court the other day, and they do the prisoners before they do the general public. And it was a guy in there, he said, Your Honor, I've been sitting here for 2 years, man. Family members are passing on this and that. I had somebody write an affidavit that wasn't my house. Hold on, sir, everything is on the record. I'd be careful what you say out here in the public, and you shouldn't be speaking on the details of your case. That's for your attorney to deal with at the appropriate time. Shut up. You gave your power of attorney, your right to speak, your right to stand on your own square to this guy who's an officer of their regime. Make sense? Well, it doesn't make sense to me. But a client is one who applies to a lawyer or counselor for advice and direction in a question of law, or commits his cause to his management in prosecuting a claim or defending against a suit in the court of justice or court of justice, Article 3, judicial. One who retains the attorney is responsible to him for his fees, and to whom the attorney is responsible for the management of the suit. One who communicates facts to an attorney expecting professional advice. Clients are also called wards of the court in regard to their relationship with their attorneys. They let you know you're a ward of the court. My buddy, my fair buddy, you're incompetent. So if you're incompetent, after we process you and send you through the system, since you're a ward of the court, we are going to send you to a prison where the highest figure in authority in a prison is a warden. Make sense? So let's see what the word ward means. According to Black's Law Dictionary, 4th edition, page 1754, a ward, guarding, care, charge, as the ward of a castle. So in phrase, watch and ward. So he's guarding you. You're incompetent. You're in his care. He's in charge. You're a ward of the court. So on the next page, which is 1755 in the same dictionary, Black's Law Dictionary, 4th edition, it says ward of court, infants and persons of unsound mind. Where my weed at? I had to go consult the vine. I had to go, go consult this wonderful herb right here that my Father God put here for me to release my mind to certain things. So that was a big pill to swallow. In Corpus Juris Secundum, Volume 7, Section 4, it tells you that clients are also called wards of the court. And in Black's Law Dictionary, a ward of the court are infants and persons of unsound mind. They said you is out of your cotton picking mind to hire one of us to defend you against another one of us. Yeah, that is very unsound. That's what you are, a ward of the court. What a ward of an infant, an unsound mind. So you're not in your sound mind to remove yourself from your proper person, appropriate persona, and let somebody else stand in with that wife of yours, that girlfriend of yours that you love so much. Would you step out and let another man step in? Can he do your job better than you? I mean, it's the same situation if you look at it. You wouldn't step out of the space of being a man for your woman to let another man step in, would you? So why would you do it in defense of yourself? do such a thing? Because you're of unsound mind. That's why you did it. And you're an infant. A mental infant. You don't know what's going on here. So, in one's own proper person, it was formerly a rule in pleading that pleas to the jurisdiction of the court must be pled in appropriate persona, because if pleaded by attorney, they admit the jurisdiction. As an attorney is an officer of the court, and he is presumed to plead after having obtained leave, which is permission, which admits the jurisdiction. Hey, I need you to defend me in this criminal case. All right, you're admitting to the jurisdiction of the court. He's not going to tell you that. Hell yeah, $30,000. Put it in a brown envelope. Drop it off in the morning. Hey, good morning, Judge. Good morning, Your Honor. Hey, my client, this and that. And they sound real good getting you continuances for 3 years. Hey, man, the state said they ready to shake a leg, man. You want to take a deal? What did I pay you 30 grand for? Because you're of unsound mind. That's why you paid them 30 grand. So when you hire an attorney, you become a ward of the court. A second-class citizen. A fiction. Why would you abandon your status and your dominion over the earth in which the Almighty Creator gave you to let a barrister represent you? Represent you. Represent you. I'm here the living man. Who can represent a living man? In the Bible, before Satan went and tested Job, he had to go ask permission from God himself. And it says in the scripture that in the court, in the heavenly court, it says Satan presented himself. It didn't say Satan pulled up represented by lawyer John Doe, attorney at law. Lawyer John Doe number 2, attorney at law. Yeah, I paid him $100,000 a piece. Satan didn't pull up like that. Satan know he had to come to God in this proper person. You can't come holler at me with no third party. I want to talk to you face to face. I bet you I can make your man's Job flip. Bro, I can test him. I can get him to condemn you. I know I can get Job to flip on you. All right. You can test him. Just don't kill him. And Job stayed solid. He held it down. Job held it down, bro. That's why God blessed him. Over blessed him. And so what do you think happens when you hold it down right here in the courtroom? Do you think the Father who you represent, yeah, you represent God when you stand in the court. Because you're in his image and likeness. Yeah. You don't want to be represented. You want to present yourself. So you hold it down for the cause. You hold it down because you know you're going to be blessed. And not only because you're going to be blessed, because it's the right thing to do, not compromise your integrity in any situation. So you holding it down. You standing on business. You talking about you doing God work? Yeah, you are doing God's work, but I'm doing it in a different way. I don't have to dress up in no suit and go sit and holler and scream in church or on the street. You said you're a soldier in the army. Okay. I'm front line though. So everybody has a position. I'm playing mine. But in a situation where ones are in danger, you're not fighting for yourself. You're fighting for the man on side of you. You're fighting for your family. You're fighting for your freedom. You're fighting for your sanity. You're fighting for your place in the cosmos after you transition. You fight for a lot of things. You fight about how much money Shaquille O'Neal is worth. You fight about a parking spot. You fight about who had the most money between you and your brother last year. With passion. But when you walk into this arena, you don't even want to fight, period. You immediately step out your steed and put somebody else in there. I've used this before. That's like you get into it with my brother and you hire me to come defend you from him. I'm going to make it look good. Yeah. Hey, bro, stop playing with him. We're going to fake fight and everything. But the joke's on you. Because after we fake it with each other, then we turn our attention towards you. Infant. Person of unsound mind. You're awarded the court. Man, this some bullshit. I'm pretty sure it is. I'm pretty sure it is some bullshit. So, another thing. Y'all use the word interchangeably, attorney and lawyer. Black's Law Dictionary, 4th edition, page 1033. A lawyer is a person learned in the law. In another instance, as an attorney, counsel, or solicitor. In another instance, a person licensed to practice law. So how can somebody be licensed to practice law if the practice of the law cannot be licensed? Because it's an occupation of the common right. Because maybe attorneys need a license to represent a fiction. A bar card. You have to have a bar card to practice law. Oh, I didn't know that. Well, the first context that the word lawyer is used in, a person learned in law. I can say I'm learned in law, but this is a continuous journey. It started out with me learning words. Where are you going to start? It takes one step to start a 1,000-mile journey. You ready to take that step? So I'm a lawyer. Yeah, I am a lawyer. Because I'm learning the law. So that's why they have two different distinct people when it comes to who's who. You got the lawyers and you got the laymen. That's why they say in layman's term. Well, what is a layman? According to Black's Law Dictionary, page 1033, 4th edition, it says a layman is one of the people and not one of the clergy. One who was not of legal profession. Okay? Or one who was not of a particular profession. They say shit. One not of the legal profession is a layman. So they say, let's just say in layman's term, because when they talk what they talk, you don't understand it. So what you just say? Okay, so we want to say it in layman's term, which is where a child can understand it. Now, me being a lawyer, know that these actors are bound from certain things. So, in Trenzi versus Pagliaro, an attorney for the plaintiff cannot admit evidence into the court. He is either an attorney or a witness. He's presenting evidence before the court. So is he witnessing on behalf of the state of, or is he an attorney for the state of? Because he's the one bringing the action against your monopoly piece. And he's basically attesting to the facts. So he's a witness. You can't be both. So in the federal rules of evidence and the state rules of evidence, there must be a competent first-hand witness. There has to be a living human being making a complaint and bringing evidence before the court. Corporations are paper and can't testify. Sir, Were you there when the state of Illinois was damaged by my conduct? Did you witness that? Well, the state of Illinois wasn't there. So, I mean, they're the one bringing the action. So how is somebody who's not an injured party bringing the action? So, no instruction was asked, The prosecutor is not a witness, and he should not be permitted to add to the record either by subtle or gross improprieties. Those who have experienced the full thrust and the power of the government when leveled against them know that the only protection the citizen has is in the requirement for a fair trial. Donnelly versus De Cristoforo. Yeah, they just let you know right there, out in the open. Yeah, the only little remedy you got is a trial, my boy. But you got to see it through, my boy. We got to see it through. In Transient versus Pagliaro, once again, statements of counsel in brief or in argument are not sufficient for a motion to dismiss or for summary judgment. Statements in of counsel in brief or in argument are not facts before the court and therefore are insufficient for a motion to dismiss or summary judgment. Pro per and pro se litigants should therefore always remember that the majority of the time, the motion to dismiss a case is only argued by the opening attorney who is not allowed to testify on the facts of the case. The motion to dismiss is never argued by the real party in interest. They tell you what's going on. In Porter versus Porter, it says that the practice of an attorney filing an affidavit on behalf of his client asserting the status of the client is not approved, inasmuch as not only does the affidavit become hearsay, but it places the attorney in a position of a witness, thus compromising his role as advocate. Do you see the things that they do? How they lead witnesses, how they enter evidence into the record on behalf of their client? That's hearsay. Because you can't attest to it. If you can't attest to it, then you're not an attorney, you're a witness, sir. So if you're going to make any statements in regards to evidence, one ought to be sworn in and deposed. Am I wrong for standing on my rights? I never claimed that you violated my rights directly. I'm making a claim that you're exceeding your authority, and that indirectly violates my rights. Ones must be grounded, standing on that square. Don't let nobody stand in your steed. Don't let nobody represent the likes of you, because that's not you. And the real you gets no remedy if you allow this to happen. In certain cases, yes, a competent counsel is to be advised. But when it's time for someone, especially a fiction, bringing an action against a national, the living man, then you need not hire anyone for educational purposes. If any of this was educational, informational, or entertaining to you, then click and subscribe. Go through those videos and see what you need for your benefit. But, ask yourself a few questions before you go into a public play thinking that you may want to hire an attorney. Peace to all my American nationals. Islam to the Moors, and assalamu alaikum to my Muslim family.